Hello everyone and welcome to Legal Studies Unit 4, Area of Study 1, The People and the Australian Constitution, Part 3. The focus of today's video will be dot point 4, the means by which the Australian Constitution acts as a check on Parliament in lawmaking, including the bicameral structure of the Commonwealth Parliament, the separation of the legislative, executive and judicial powers, the express protection of rights, the role of the High Court in interpreting the Australian Constitution, and the requirement for a double majority in a referendum. Let's begin by looking at the bicameral structure of the Commonwealth Parliament. The Australian Constitution states that the Commonwealth Parliament should comprise of two houses. The bicameral system requires Commonwealth legislation to be passed by both houses of Parliament before it can receive royal assent. Most bills are introduced in the House of Representatives, so the Senate is designed to operate as a house of review. This allows senators to vote for or against the bill not only according to the views of their political party, but also the interests of their state. So when might the bicameral structure not act as a check on Parliament in lawmaking? Well, if the government holds a majority in both houses, the Senate may act as a rubber stamp rather than a house of review. Ultimately, this may mean that there is not enough scrutiny of the bills passed. The separation of the legislative, executive and judicial powers. It is important that we don't confuse the separation of powers with the division of powers. I might create a video later on looking at both and how we can differentiate between the two. So, there are three main powers that must be performed within any legal system. Laws must be made, that is the legislative power exercised by the Parliament. Laws must be administered, that is the executive power exercised by the executive, and laws must be applied when disputes arise, and this is the judicial power exercised by the courts. The legislative power is found in Section 1 of the Australian Constitution. This power is exercised through Parliament. It's comprised of the Queen, represented by the Governor-General, the Senate, and the House of Representatives. The Parliament has the power to make and change laws, called legislation, in areas that are listed in the Australian Constitution. The executive power is found in Section 61 of the Australian Constitution. It includes the administration of laws and the business of government. In practice, this is carried out by the Prime Minister, senior ministers and government departments. It has the power to look after existing laws, suggest new laws and put laws into action through government department. The judicial power is found in Section 71 of the Australian Constitution. This power is given to the courts to interpret the law. The judiciary has the power to interpret laws and judge whether particular laws apply in individual cases. The courts are independent of the legislative and executive functions. Therefore, the courts are not subject to any political interference. The question is, are they really separate? In theory, there is a separation of powers between the executive and the legislative functions. In practice, however, this distinction is blurred. And this is because the party that holds a majority of the lower house performing the legislative function are also ministers of government performing the executive function. So basically, those in the lower house who are introducing new laws, changing laws, are also those who administer laws, so senior ministers and the Prime Minister. So whilst in theory the powers are separated, in practice they may not be. Let's now look at some of the strengths and limitations of the separation of powers. Let's begin by looking at the strengths. The separation of powers allows for the executive to be scrutinised by the legislature. The separation of powers also means that the judiciary is independent of the two other arms. Some of the limitations, however, include that in reality, there is a significant overlap between the legislature and the executive. There are ministers in both arms, and this is what we looked at in the previous slide. Are they really separate? And there is a reduced level of scrutiny in this situation. Another limitation is that whilst the judiciary is independent of the two other arms, judges are actually appointed by the executive, so the executive can influence the composition of the bench. And when the government controls both houses, there will be less discussion and scrutiny regarding decisions of the executive. The express protection of rights. Express rights are stated in the words of the Constitution. They are entrenched in the Constitution, meaning that they can only be changed by a successful referendum. The Commonwealth Parliament cannot pass legislation that infringes express rights. The 5 express rights are freedom of religion, free interstate trade and commerce, the acquisition of property on just terms, trial by jury for Commonwealth indictable offences, and freedom from discrimination based on state of residence. So you would have looked at these more in depth in class. However, for the purpose of this video, I'm just going to briefly list them. Express rights restrict Parliament's lawmaking. This is a strength because express rights were written to intentionally limit Parliament's lawmaking in specific areas. This is a limitation because express rights are limited in number and in scope. Also, Parliament can still pass laws that infringe express rights, and they will only be invalid if the High Court declares them to be. We will look at in a later slide the amount of money and time it takes to take a matter to the High Court, as well as the requirement for standing. Express rights, as we mentioned, are entrenched in the Constitution. This is a strength because they are difficult to change. They require a successful referendum to change the words, and we will look at how difficult it is for a referendum to achieve the double majority provision in a later slide. This is also a strength because Parliament can't just change express rights when they feel like it. A limitation, however, is that they are scattered throughout the Constitution, meaning that they are difficult to locate. There's no one section that says express rights and all 5 are stated. They are also difficult to change or add new rights or amend existing rights for better protection, and the High Court can alter the meaning of the section without changing the words. The role of the High Court in interpreting the Australian Constitution. The High Court was established under Section 71 of the Australian Constitution. Section 76 gives the High Court the exclusive jurisdiction to hear disputes involving the interpretation of the Constitution. Individuals or groups can challenge the constitutional validity of legislation in the High Court if they can prove they have standing. The High Courts check on any abuse of power. Individuals, groups, states, territories, and Commonwealth bodies may argue that a state, territory, or Commonwealth Parliament has made a law outside of its lawmaking power. If the body has standing, they can bring the matter to the High Court for a ruling as to whether the law is unconstitutional. The High Court justices consider the material facts, listen to the Council's submissions based on law, and hand down their judgment. The High Court gives meaning to the words of the Australian Constitution. The High Court interprets the words of the Constitution and applies them to the case before the court. In doing so, the High Court will either confirm the right of the lawmaker or deny it. The High Court can either broaden the interpretation of the word or narrow the interpretation. Looking at broadening the interpretation, the wording is interpreted in an expansive way, with more material included. this is often referred to as widening the scope of the words. On the other hand, narrowing the interpretation refers to the wording being interpreted in a more restrictive way with less material included, and this is often referred to as narrowing the scope of the words. The High Court is independent. This is a strength as judges are independent of the legislative and executive and are not influenced by political pressures. Judges are not elected by the public, meaning that they will not make amendments or changes to laws that reflect what the public want, but rather the case in front of them and what is necessary for effective lawmaking and change. Also, the Parliament cannot override a High Court ruling on constitutional matters. A limitation, however, is that the High Court must wait for a case to come before the court by somebody with standing in order to act as a check on Parliament's lawmaking. It is extremely costly to take a matter to the High Court, and it is also very time-consuming. So while someone may want to challenge the constitutional validity of a law, they may not have standing, they may not have the means financially, or they may not have the time, so it is extremely difficult. Looking at interpreting the Constitution, this is a strength because the High Court can interpret the words of the Constitution and give them meaning to apply to the case before the court. Also, the High Court can keep the Constitution relevant and up to date. Some of the limitations include that parties may be deterred from bringing a case to the High Court because of the costs, as we mentioned. The interpretation often depends on the composition of the bench at the time, so whether or not they are active or more conservative. Another limitation is that the High Court cannot change the words of the Constitution, and they must wait for a case to come before the courts to interpret the law. The requirement for a double majority in a referendum. What is a referendum? A referendum is a compulsory vote on a proposed change to the wording of the Constitution. A referendum is the only way the actual words in the Constitution can be changed. The process for a referendum is outlined in section 128 of the Constitution. There are many stages of a referendum which you would have looked at, but for the purpose of this video we'll be looking at stage 2, the people and the double majority provision. For the referendum to pass, each question must satisfy the double majority provision of section 128. So this is that a majority of voters in the whole of Australia, including territories, must vote yes to the change. And a majority of voters in the majority of states must vote yes to the change. Parliament cannot alter the Constitution without a referendum that satisfies the double majority provision. The double majority provision of section 128 is intentionally difficult to achieve so that changes without the support of the people cannot occur. It is therefore difficult for Parliament to alter the Constitution to make any changes, including changes to their lawmaking powers. In order to illustrate the difficulty of achieving a successful referendum, I have included some statistics. So only 8 out of the 44 referendums put to the people of Australia since 1901 have satisfied the double majority provision and changed the Constitution. So this means 36 out of the 44 referendums have failed. 13 of the 44 referendums have satisfied one of the requirements for the double majority, but failed to satisfy the second requirement. The support of the public and states is required to change the Constitution. This is a strength because smaller states are protected. Members of the public are also informed about the reasons for and against the proposal. Usually, members of the public will receive in the mail a brochure that clearly states the arguments for and against the proposal. Some limitations include that members of the public, despite receiving these brochures, may not fully understand the proposed change and therefore vote against it to avoid uncertainty. People usually don't like change, so this could be the easiest and safest option for them. Also, referendums without bipartisan support are unlikely to pass, and this is because there are likely to be conflicting views between political parties. The requirement for a double majority in a referendum protects the Constitution. So this is a strength because the Parliament cannot change the Constitution easily and therefore cannot easily increase their lawmaking powers. Some of the limitations, however, include that the double majority provision, as we spoke about earlier, is difficult to achieve. And this may be a big limitation as it may prevent necessary changes being made. Also, many Australians don't understand the Constitution or the impacts that it may have, and therefore tend to be conservative and are more likely to vote against the changes to avoid adverse effects. So if you're not well versed in the Constitution, you may be more inclined to vote no to the proposed changes as a means of avoiding the ramifications that may come about because of the new change. That concludes today's video. I hope that your knowledge of dot point 4 from Unit 4 Area of Study 1 has been consolidated. As always, if you do have any questions, feel free to leave them in the comments below or send me an email. Thank you.